Good afternoon, friends. It's so good to see you out there on live stream land. Thanks for joining us today for the inaugural event in our community care series, Truth, Knowledge, and Power. At TRHT, we've realized in battling systemic issues, we realize that there's also a lack of a focus on community care. We talk about taking care of ourselves, but what about those who take care of us, and how are we taking care of others? So when we think about self-care, community care should go hand in hand with that. So, for our inaugural event, we're going to be talking about wills and trusts. I'm going to invite our actual host of this broadcast, retired Captain Stacy Ledbetter, to introduce our speaker for this afternoon.
Thank you, co-director Francis Vicioso, and thank you so much for handling our tech today behind the scenes. Greetings, everybody. We are glad you are here to join us today, and we are super excited about our special guest, our inaugural special guest, who is going to be talking to us about wills and trusts. That sounds big. It sounds highfalutin maybe to some, but it's important to all of us. And presenting today will be Ian Hamilton Esquire. She's an attorney and counselor at law. She's a proprietor with her husband, Phil Hamilton, of Hamilton Law, PLC, estate planning and business. And also, I want to give them a shout out for being a supporter of the Truth, Racial Healing and Transformation Law Team's signature event, which is expanding our horizons, which brings together community and future law enforcement officers. So we appreciate your support, Attorney Hamilton. And so we actually want to jump right into it, just letting everybody know out there, if you're watching on Facebook Live or even have the access, and thank you to Public Media Network for this StreamYard platform. You can put your questions or comments in the chat, and we'll do our best during Attorney Hamilton's presentation to get them to her to address them in real time. But also, after today or after this present moment, this recording will be available so we can continue to share this important information. So, without further ado, Attorney Ian Hamilton, take it away, giving us information about wills and trusts. Thank you so much for being here.
Thank you, Stacey. Thank you so much. So yes, let's get started. This is a topic that is so important to everyone. No one should be left out of discussing what it means to have an estate plan and why we should have an estate plan. So the main thing that I hope you each take away from this presentation is that estate planning, it is not one size fits all. Each plan, each estate plan, whether it be a will, a trust, a power of attorney, it's tailored to each individual. Not every family is the same. People may be wealthier, people may not have a big family, they may only have two people in their family. It just depends on what your family situation is. However, everyone does need an estate plan. And just putting down your wants and needs and wishes for your estate plan, it's important to do, and we'll talk about why that is today. So what I really want you to think about today is, what is your reason for estate planning? Why should you put together an estate plan? We are going to go through many of those reasons today, and hopefully, going away from this presentation today, you can come away with, why is it that I need to plan? What's that trigger that's in your mind when we discuss today that makes you want to plan ahead? We're going to talk about several of those today. So one of the most compelling reasons that people come to me and say, I need to put an estate plan together, is preventing probate. It's a very, very, very good reason to plan. I'm sure many of you have heard about probate, the horrors of probate, and I'm going to explain what that is. So probate is the process by which, if you pass away with an asset that is just titled in your name alone and doesn't have another person or a beneficiary, or is titled into a trust, and we'll talk about that in a minute, it's going to have to go through a process with the probate court in order for it to be transferred to your loved ones. Why do we want to avoid probate court? The reason is, it takes minimum 5 months to complete probate. It also requires attorney's fees, filing fees in the court, just extra time, money that can be avoided if a proper estate plan is put into place. So we're going to talk about a few ways to avoid probate. And the first one, a lot of you may have already done, and that's joint ownership of assets. So if you own an asset jointly with someone, let's say on a bank account, real property, if you're married and you and your spouse own that property jointly, that is going to avoid probate on the death of one person. So that one joint owner may pass away, it's going to automatically pass to the person that's left on that property. That's going to avoid probate. So if nothing else, joint ownership is a wonderful way to avoid probate. However, the problem with joint ownership is that if both people that are on that joint asset pass away at the same time, and that's my job as an attorney to think of the worst scenario ever, but it does happen, and I'm sorry. But if two people on that joint asset pass away together, probate is going to happen. So again, joint ownership, it works to an extent, but we want to plan a little bit further to determine how we can avoid probate. So another way to avoid probate, right on the screen there, beneficiary designations. Again, a lot of you have likely heard of this. If you have a retirement plan, life insurance, any asset that allows you to fill out a beneficiary form, make sure you do it. If you leave that blank, the beneficiary designation blank, then that means you're going to probate. So for a lot of people, it's very simple. You can go to the bank, they'll give you a form. You can add a beneficiary designation to your bank account. You have the ability to add it to life insurance. You have the ability to add it to 401k, IRA, HSA plans. Adding a beneficiary designation on that account will avoid probate. Another way to avoid probate using beneficiary designations, a lot of people ask, what about my real property? Can I put a beneficiary designation on my real property? The answer to that question is yes. You have the ability to name a beneficiary right in the deed to your property so that you own that property while you're living. Nothing changes. You can mortgage the property, you can sell the property, you can do whatever you want with the property while you're living, but you can name a beneficiary to receive that property at your death. So that's an awesome way to avoid probate. A lot of people are really nervous about naming someone else in their deed, but I want to reiterate that it does not give that person that you name as a beneficiary in the deed, rights to the property while you're still living. It only just prevents probate from occurring at death, and that property will be transferred outside of probate to that person. So if we choose the first two ways to avoid probate, joint ownership of assets or beneficiary designations, we still want a last will and testament to be drafted and to be put in place. Now, I first want to bust a huge myth that a lot of people state, and I want to make sure everybody understands that having a last will and testament does not prevent probate. I'm going to say that again because a lot of people think if I have a will, I'm preventing probate. That is not true. Having joint ownership of assets with someone else, and if you pass away first, that prevents probate. Also, having beneficiary designations on your accounts will prevent probate. But I still want each individual over the age of 18 to have a will in place, even if they're putting beneficiary designations and joint ownership of assets. The reason for the will is that sometimes people do forget to update beneficiary designations, to add a joint owner, and that asset that does not have a beneficiary designation or does not have a joint owner on the account is unfortunately going to have to go through probate. But having that will in place where you're able to specify who you want to receive your assets at your death is critical. Again, having the will won't prevent probate, but it will give the court guidance about who you want to receive your assets. And having that independence and that freedom to name who you want is critical. So even if you are choosing those two ways to prevent probate, having a will is key. So the third way to prevent probate, right on the screen there, is a revocable living trust. And so I want to make sure that I give you the differences between having a will, having those beneficiary designations or joint ownership versus a trust. So a trust, I want you to think about it as, number one, any asset that is going to be titled into the trust is going to avoid probate. So you can retitle your home into the trust instead of putting a beneficiary designation on it. We would retitle it into the trust. You can retitle your bank account into this trust. All of your assets can be retitled into a revocable living trust. And what a revocable living trust is, it's a document where you are able to specify what exactly you want to occur with those assets that are retitled into that trust at your death. So comparing the beneficiary designation and the trust, if you name beneficiaries on your assets, those people that are named as beneficiaries are going to get assets outright, right at your death, with no specifications involved. Literally, they will receive assets outright. With a trust, if you name your asset in the trust, you can specify in that trust document what you want to happen. So if you don't want your kids to receive those assets until they're 25 or 30 or 35, you can specify that in the trust. You are not able to do that with beneficiary designations. So if you're thinking, do I need a trust? I recommend a revocable living trust plan instead of a beneficiary designation plan for people who may have minor children. We don't know, when you have kids, what they may be doing at age 20, at 18. If you pass away and have them listed as a beneficiary, that's not going to prevent them for getting assets outright at age 18. So having a trust allows you to be more specific and put parameters around when you believe that your children should receive assets.
Attorney Hamilton, I'll jump in just so I can keep the flow and respect our viewers.
Thank you.
There's no problem. There's a question from Brother Jacob Mabry asking about family property. If your home is lost and gone through probate and a will is in place, is there any way for family to recover property legally if it's already been sold and not in the family name? And then he goes on to say he's heard about legacy laws. Is that something you could pull in? I'll stop there.
So unfortunately, and that has to do with if your family did not actually put together an estate plan and, probate had to occur. So when you are in probate and the house has already, been sold out of the family because no planning was done, unfortunately, it is difficult to get that property back. And, obviously every situation is different. So, Jacob, I'd be happy to sit down with you to discuss it further. But once you get into probate, if that house is sold and out of the family, it is very difficult to get it back.
And he clarified, he said, or will is not in place. And Ms. Tanya Bellamy added on, does the trust help avoid gift taxes?
Good question. So a trust does not help to avoid gift taxes. However, while you're living, you have the ability to make gifts up to a certain amount throughout your lifetime. So right now, the federal limit is at $12.06 million that you can gift throughout your lifetime. So there are ways, there's different types of trust, not the revocable trust that we're talking about, that if you are gifting more than that amount, that we can draft a different type of trust to help prevent, any taxes that may occur over that amount. So the type of trust I'm talking about here, the revocable kind, no, but there are different types of trust that would allow that.
That was a great question. And the next one is for now, and we will let you go on after this one.
Okay.
What makes a will official?
Great question. So there are two types of wills. One type is called a holographic will. And this a lot of people don't know about. And what makes this type of will official is if you write in your own handwriting your wishes and sign and date it, that is a valid will in the eyes of Michigan law. The other type of valid will is, a will that's typed up, probably one that you've seen before, but it has to be signed by the testator, which is the person that's making the will, and also should be notarized as well as witnessed by two individuals. And that would make a valid will. Okay. So just digging just a little bit deeper on, that trust, I would definitely say that I would be happy to listen to what your family situation is. Like I said, one one size does not fit all for estate planning. So a trust may not be needed. But again, minor children, if you have, a beneficiary that you want to leave assets to that may have, drug problems or something, or special needs, something that you don't want assets held outright or given outright to them, that's when I would recommend a trust. And a trust allows you to avoid probate, which is huge. And it also, different from a will, is kept private, which is also a great thing to know. Any other questions before I move on?
Looks like we are good for now, so you can keep it moving.
Okay.
Thank you.
So let's keep talking about other reasons to plan. Why? So nominating a guardian, this is huge. So I have minor kids, I have 2 little boys. You don't want to think about it, but if something happens to me and my husband, we want to make sure that we are able to specify who we wish to take care of our kids if something happens to us. There's a lot of people who, have in-laws that maybe don't get along. So many different reasons, but giving you that power and that authority to nominate who will take care of your kids if something happens to you, your minor children, is huge. And that would be in a last will and testament, is where we would make that nomination. Okay. And then we also want to talk about reasons to plan as far as incapacity. So a lot of people, when they think, putting together an estate plan, they think this only means a will or a trust. It only takes care of me when I die. But estate plan also encompasses what happens if I'm living, but I become incapacitated. There are more and more individuals, in our lifetime that are having dementia or just episodes that we never would expect to happen. And so if you do not have a durable power of attorney for finances or a durable medical power of attorney in place, if you become incapacitated, your loved ones will have to go to court to seek a guardianship or conservatorship over you in order to make decisions in regards to your finances and medical. So any adult over the age of 18 should have a financial power of attorney in place. And what you would do in that document is you would name a primary person to make those decisions for you if you're unable to do so for yourself. And it doesn't have to be for, your whole life. It might just be a period of time where someone will step in to make those decisions for you. Also, choosing a backup is critical. In your durable medical power of attorney, if 2 doctors state in writing that you're incapacitated and cannot make medical decisions for yourself, naming that primary person to make those decisions for you, as well as a backup, is crucial. Also, within that medical power of attorney, you're going to want to choose your advanced medical directive. And that means that if a doctor states that you're in a vegetative state and there's no likelihood that you'll survive, you can choose ahead of time if you want extraordinary measures to prolong your life. And the reason why we want to put that in writing ahead of time is so that your loved ones don't have to come up with that decision for you. There's sometimes a lot of guilt associated with, pulling the plug or making a decision that, they have to think about for the rest of their lives that they made, possibly to end your life. Putting that in writing so that they don't have to make that decision is crucial.
Attorney Hamilton, let me jump in there on this topic with a few things. You made me think about some things, and we do have a question in the chat. And because you said that's a sensitive and difficult time for people if they have to make those decisions, if the person doesn't have them documented. But what would happen because of the emotional difficulty if family tried to change it? Like the person wants you to pull the plug and the family's like, I just can't say that right now. What are the legalities there?
So anytime that it's not followed, probate court can get involved. So if there's a family member that states, I see that they're not making this decision that's in this legal document, they can file a petition with a probate court stating that the person nominated is not following what the person has stated. And so hopefully, and this is something to think about when you're putting together these documents, that you do choose a person who would make the decision that you've put in the documents. It's kind of funny. I do this for a living, but my own mom did not choose me as her medical power of attorney because I would just be too emotional. You really have to pick the person that would make that right decision. Really good.
Thank you. And with what you were talking about with wills, like literally just those alternatives if people don't get these services professionally done, does the same thing happen with this advanced medical directive and everything that you're talking about now? And I notice hospitals are stepping up with asking these types of questions. You know, who do you want us to go to if you can't talk to us? That type of thing. So whether it's with the hospital or at your own hand on that paper that you mentioned that you sign, is
Mhm.
that legal? Will that hold up?
It will. And so those are great. And I am not, of course, I and other attorneys probably think our documents are better than what the hospital is giving, but I'm being honest, those will work. Just having something is legal and, signed by you, dated by you, have that in place. The reason why we do what we do is because we want to make sure it's all encompassing, that something's not left out, because we've had and seen so many things occur that maybe, a hospital who's giving you that form may not think of. But yes, writing it down is still valid and having that signed. Great.
Thank you so much. And I want to pose a question from Julie. I'm going to say Julie L. so I don't mess up your name. But here's her question: where or with whom should a will be kept so that it's accessible at time of death? Should multiple people keep copies?
Great, great question. I always just tell my clients, keep that will in a safe place. It also depends on your attorney. So at our office, we will keep your original will and obviously copies of your will. So we will always have that available. The one thing that you have to remember about probate, if you ever are going to probate, the probate court wants an original will. And so keeping that original will in a safe place, in a safe, it does not have to be filed with the court. It can be, but it's not required once it's signed. But if you're afraid you're going to lose it, you can always file ahead of time with the probate court. But yes, great idea, giving multiple copies to friends, family members, but really knowing where that original is super important in case there is probate.
And we are good. You can continue. Thank you so much.
Yeah. So another reason to plan, specifying final wishes. And now this is a little morbid, I'm sorry. But there's a lot of times where again, fighting occurs. When you pass away, we don't want your loved ones to be fighting over, who is going to, write the obituary, where should you be cremated, should you not be cremated. Specifying these final wishes ahead of time really resolves conflict among your loved ones, and choosing a funeral representative as that person to make decisions at that time if you already don't have them in place. So a lot of people do go, to a funeral home ahead of time and put things into place, but specifying and nominating someone to make these decisions for you so that there's no fighting is huge. And that's another document that I would recommend putting together with your estate plan. In that funeral representative designation and final wishes, you can also state, do I want a funeral? Do I want a viewing? I've heard of so many different, things. People want a party. You are able to specify ahead of time. And that's really what estate planning is about, is having the control and, the independence to be able to do it before it happens. And so definitely recommend a funeral representative designation. So before we move on, and Stacy, I am getting close to the end, but I do have, a slide here regarding our fees, but I just want to talk about how everything kind of goes together. And so with an estate plan, we want to make sure that everything is covered. So as we talked about, there's documents in place if you pass away. There's documents that are going to be in place if you become incapacitated. And so we recommend not just doing one document, but to have all of the documents in place. So if you came to me and we determined that a trust is the best option for your family based on your situation, we would put together a trust for you. We would still have a will. And when you have a trust and a will together, what that does is, if you have minor children in that will, you're going to be naming a guardian, but also it's going to work together with your trust. If you forget to retitle something into that trust, the will is going to cover all your bases. And we can explain that more in person if we do meet. with those two documents. Those are going to take care of your wishes at your death. Then you're going to have your power of attorney for finances with those two. Who's going to make financial decisions for you if you're unable to do so for yourself? Then you're going to have a durable medical power of attorney, like we discussed. Again, I'm still living, but who's going to make medical decisions for me? Also in that is that advanced medical directive. And finally, we're going to have that funeral representative designation. Who's going to make those decisions in regard to my funeral, obituary, etc. And so our office, if you just take a look, and we are super transparent about our fees, and this is all on our website. We just want people to know, a lot of people think it costs a ton to do estate planning, but we want you to know that doing it now, rather than waiting until probate occurs, you're going to save a lot in the long run. But as you can see, if you do that trust package at the bottom, that's where you're getting that revocable living trust, the will, the powers of attorney, durable medical, and financial. We also make sure that we do a new deed for you to make sure your property is in the trust. And those are the prices there for an individual and then for a couple. And the same thing you'll see for the last will and testament package, and as well as if you have a deed, those are the different prices right there. So everything is transparent and upfront and flat fees, which we like.
And that answered Ms. Kia Delaney's question. So thanks for being transparent about the fees. And Ebony Hemphill would like to know, can you give us a quick comparison of a trust fund versus an endowment? Like, are those items that are wrapped into the information that you're talking about right now?
So they're different. So a trust fund is something that is set up like this revocable living trust that we're talking about, typically by a family member who's going to be leaving assets to a child or another family member. So they're putting away assets into a trust that's titled, in their family name or in their individual name, and that's held until they pass away, and then it's held based on the terms of the trust for the beneficiary that they're leaving it to. An endowment is different. It's usually larger. It's something that is created while you're living and you're not using it. And it is totally separate. You get a tax ID number while you're living. It's not really a estate planning document, or it's not used to distribute assets usually to your heirs. It's usually held for a longer period of time and has a charitable association or affiliation to it.
Thank you. And what about, and shout out to Ebony, she is in the TRHT family, our coordinator. Julie L wants to know, do power of attorney, as far as power of attorney goes, do they get the decision-making power only after one has been considered incapacitated?
Great question. Really great question. So I will clarify right now that yes, for a durable financial power of attorney, that word durable allows the person that's nominated in that document to make decisions for you for finances, whether or not you're incapacitated. And you think, that's kind of weird, but there are situations that occur where, let's say you're buying property and you're unable to be there to sign for that property. Your power of attorney can sign on your behalf, even if you're not incapacitated. However, there are other types of powers of attorney, because that one sometimes makes people nervous. I'm not incapacitated. Why would I give up that authority? So there are other types. There's one called a springing power of attorney that allows you to only allow that person that you named to make those decisions for you if you become incapacitated. I had a client in yesterday, same thing. She wasn't married, but in a relationship, but she just wasn't really into having that person, make decisions if she was not incapacitated. So we did a springing power of attorney.
Thank you. And yeah, you definitely hit on something right there. And just even with my career background in law enforcement and going to interact with community members at all points and situations in their lives. And that's a biggie. You talk about when people are not married, or even when there's, numerous siblings or no children. We wanted to do this, like Francis said at the beginning, that just encompassing community care, attorney which is tied with self-care, which is tied to peace of mind.
Yeah.
So folks can just be comfortable, because even just having this informal conversation with various people, they are even uncomfortable sometimes talking about what happens upon their death. And
Yeah.
so facing our mortality, if you will, can be very difficult. But we just wanted to encourage people to, at the minimum, have the conversation. So because people are at different places in their lives, let me just ask, just so people know, even before calling you, so they don't have to ask. If it's like, hey, I don't have that amount right now, do you offer any type of plan, or do they need to save before they come to you, and because they want to do
Oh,
it?
great question. So we understand sometimes, you want to do this planning. We don't want the financial part of estate planning and of having an attorney to deter you. So we do. If you're only able to make $100 payment, to get started, we're okay with that. We would set up payment plans. We just want to make sure that it's done. And so I don't want the price to deter anyone, because we will work with you. Which brings me to another point, and there is an article that is on our website that I would love, everyone to take a look at. But it's called, I think I title it, "The 5 Myths of Estate Planning." And what it really was, something that you just said, Stacy, that really hit me, was a lot of people say, "I don't need to plan. I don't have enough money. I don't need to plan." I hear that all the time. But that is not true. And I want everyone to understand that it's not true, because of a lot of the things that we said. Number one, the incapacity. Everyone thinks about estate planning with dying, but if you become incapacitated while you're still living, having that plan in place is critical. So that is one reason. Children, we've talked about this as well. There's so many blended families. There's, how things are these days. We don't know who would take care of our kids, who would come out of the woodwork to say that they want to become guardian. Putting the nomination in writing of who is going to take care of minor children is huge. And that has nothing to do with having a lot of money. So putting that together and putting that in place is critical. Number 3, tangible personal property. And what I mean by tangible personal property is stuff, not money, but jewelry, purses, your furniture, all of that stuff. Who is going to receive that? And what about, your heirlooms that you might, feel are very precious to you? Like, I'm sure my husband in his Michigan collection, U of M collection, wants to make sure that goes to who he wants. If you don't put that in writing for those tangible items, it's going to, I'll tell you what will happen. So we haven't talked about this, but if you don't have that will or trust in place, state law dictates, Michigan law will dictate who receives that. And that might be right in line with who you want it to go to, because they tried, the lawmakers have tried to put, a hierarchy of who they believe you'd want to receive the property. So it's typically your spouse, then your children, if not children, then parents. But a lot of people I talk to don't want to get their kids anything, and they want to skip kids and go to grandkids. So putting that in writing, even in regards to tangible items, is super important. Another important thing, oh, sorry, Stacy, I'll just go with this one quick thing. Digital assets. This is something that is becoming more common with social media, Facebook accounts, Shocker, I can't remember the name of it, with for pictures, those types of accounts, cell phones. Those are all considered digital assets, things that have access to with passwords. There are a lot of companies that will not allow family members to access your digital assets at your death, because they do not nominate you in a will, a last will and testament. So specifying that out in writing is huge, and that has nothing, again, to do with assets. It's your digital assets. Okay, Stacy, go ahead. Sorry.
Thank you. And that was huge. I'm glad you threw that in, because everybody here, the way we're connected right now,
Right.
you all know what you're talking about. You touched on it with your personal testimony, saying even your mom didn't name you because she knows your emotion. I just wanted to reiterate that part and encourage those listening to us and who will listen to your presentation to have this conversation with family and just be honest. So for instance, with my mom, I'm the oldest child. But we just had that real conversation with my brothers and who would do what or who was responsible for what. And so it's just real. We all know each other. You all know right now watching who takes care of business, who doesn't take care
Yeah.
of business, who would be irresponsible. It's just real talk. And so does your family even know, as Attorney Hamilton was explaining, your wishes upon that time, from
Yeah.
how you want the program to go, cremated or not, where you want to be, at that point, it's just so much. And hopefully this is an encouragement and spark to at least starting with the conversation. So I don't know if you have any other examples, because you and I just want to give you a shout out because we did. I mean, and Vic and I, hubby and I, our careers were over before we even came and got this situation, put together. Just in terms of taking care of business for us and our family. And so nobody should be embarrassed about what point they are in life. We're talking about it now. You mentioned 18 and over should have
Yeah.
that medical power of attorney, things we may not necessarily think about, but we all should be doing right now. And it's funny just chatting with you informally. Like you said, people make all types of designations of what they want done with their stuff. And I know
Right.
I have some of my sorority sisters watching from Delta Sigma Theta Sorority Incorporated, and even for or any Greek letter organization, even that apparel, our documents,
Yeah.
etc. When you pass on, and what happens with that stuff, upon
Yeah.
you passing on. So all those types of things. Do you have any other examples for people that may be unique or stuff we just may not be thinking about?
Yeah, and I want to touch on what you're talking about, the tangible personal property, and that's something that's super important. And we all have tangible personal property. In either a will or trust document, we would put in a general provision that states, I want all of my tangible personal property to go to whoever. We also state in there that I may leave a list or memo where I can specify specific items that I want to leave to specific people. And this is something that I tell everyone to take advantage of. We give you a specific list, it's numbered, and you can literally take, in your own handwriting and say, my, jewelry, my diamond necklace to my daughter, or my, this vehicle to my son, or this collection to whoever you want specifically, and that will be passed outside of that general provision. And a lot of people love that. One client I thought was pretty cool, and I didn't even think about this, is she had a lot of purses and bags. She took photographs of each one and, gave, each photograph a name and who it was going to go to. So that's another really cool way to do it as well. But being specific is so important, because I can't tell you how many times, I've had families in where there's a lot of fighting, sometimes about the most, not, I wouldn't say trivial because it means something to them, but things you wouldn't expect, like a dresser or a couch. Who's going to get the couch, and it wasn't specified and there's fighting. So putting a plan in place to prevent that fighting is huge.
Thank you so much. No, very, very, very informative. Why don't you wrap with telling us, out of all the areas you could have chosen in the field of law, what drew you to this important facet?
Oh, that is such a good question. So I would say that it's because when you're in the office with someone talking about putting together an estate plan, and when it's actually executed, you can literally see the sigh of relief and the peace of mind that you're bringing to clients. And I just love that part. I'm not really, my husband, as you said, practices with me. He does the fighting law, the litigation. I just don't like that messy stuff. And I really just like the peace of mind. And you can really see it in your office, the sigh of relief, that comes across people and providing that peace of mind. It's really huge. And it's what keeps me going. So that's why I chose it. Great question, Stacey.
Thank you. And when you were talking about digital assets, I don't know if I missed this, because the question is, do you have any resources on how to sort out digital assets? Or is that something you define with your packet of paperwork?
That is something that I do have. It's a provision in our will. And I'd be happy to go over it. Whoever's asking that question, please contact me. We can set up a consultation, and we do free consultation. So I would, give you that list. A lot of people, a lot of my clients, what they'll do is they'll keep a spreadsheet or a Word document with all the different types of accounts that they have. And then, with the passwords and keep it updated. Takes a lot of effort. But it really works. And then in that will, whoever you've nominated as your personal representative is going to be the person that will be able to access those digital assets.
Wonderful. And thank you for throwing that back in, depending on if somebody came in at a different point, that with Hamilton Law, PLC, you offer free consultations to have conversations with people about estate planning for their wills and or trust. You got a lot of love in the chat. People are saying, thank you. This was helpful,
wonderful,
impactful. Again, more thank yous.
Good.
Just being a blessing already. Let's see. Elizabeth Odell, hello, darling. This may have been asked, but if not, how do you remove your spouse's name on your residence, or anybody that you would need to remove to redo your paperwork, I guess it would be?
Yep. So is that in the context of them being deceased?
Let's cover both just in case, in terms of, let's talk about that deceased situation.
Sure.
Or, yeah, I guess it's messier with the other way. No, that's still my husband. How do I do
Yeah, so typically when people are coming to me, unfortunately, it does have to do with someone passing away. So we would draft a new deed, and we would also record the death certificate. And once those two, the new deed and the death certificate, are recorded together, then it's updated on the system, Register of Deeds office, to show that you are the only owner of that property. To distinguish that from a mortgage, you would have to refinance to get that person off of the mortgage. So the title to the property and the mortgage are two separate things.
And thank you for that. And Liz did acknowledge that, yes, that was, or, is a circumstance for her. But in terms of the legalities, because again, so much emotion going, and even people not even thinking about it when these situations come to be, would it mess anything up that you can think of because the, other person is deceased and you just forgot to take them off or didn't take them off?
So that kind of goes back, it doesn't mess up anything while you're still living, but that kind of goes back to that first point that I made at the beginning about joint ownership. Joint ownership is great to an extent because, if that, spouse has passed away and now the property is just in your name alone and you do nothing, there's no probate at the first death. But if you allow that to continue and then you pass away, then there's going to be probate. And so I would recommend, if you're jointly owning property with someone, they pass away, yes, there was no probate at the death of them, but it will occur at the death of you if you don't take care of that and do a beneficiary designation deed or do a trust.
Thank you so much. Yeah, definitely a lot to think about because you mentioned so many things, how we just normally conduct business or just live our lives, from the social media to whatever bank accounts you have, so many things where we have signed our name.
Yes.
And if we have ownership in it, if we don't designate, like you said, it could be some issues, or your family doesn't even know everything you've owned. Because I've seen those state websites where it's money sitting there because the family can claim it.
Yes.
But they didn't know that their family member had access or ownership to whatever that may be.
Exactly. And so that's what, estate planning, and it has the word in it, planning, it's planning ahead. And the more you can specify and put together for your loved ones ahead of time, the better. I don't know how many times where I've had a consultation where people will call in and say, well, I don't know what assets my parents had. It happens quite often. How do I find out? And it really ends up being, some investigation on your end to have to determine that. And that's difficult. Sometimes credit reports would have to be pulled to determine, what's on their credit report, what assets do they have. But if you do that ahead of time, making lists, putting everything and being organized, and we'll help you do it, you can prevent, that investigation period for your loved ones because they're already mourning. The last thing they want to, they're not going to want to go and try to figure out what assets you have.
That's awesome. So what we'll wrap up with, I might have said that twice. Hey, I'm a
No,
Baptist.
you're fine.
Thank you. Is so you've done this, you sat down, had this done professionally in terms of your estate planning, but say there's still access to somebody in the family who's in this trust who has ownership of something that the rest of the family still did not know about. Is there some, because you have a will and trust, an automatic system type of check or run so you could come across other things or funds or whatever that they may have owned? Is that even a thing?
It's really not a thing. And that's the frustrating part about it. We were laughing in the office, like we need to hire a private investigator or something to help find assets, but it is very difficult. And, a lot of people from generations ago, they would open accounts in lots of different places, different banks, different stock accounts, and it is hard to track those down. So unfortunately, there's not, a system because think about it, we try to keep our finances private from most everyone. And so there's really not a system in place. And that's why planning ahead is so important.
Thank you. That's just good to know. So now we know, just got to be real and, be honest with who we want to have that information. So again, thank you, Attorney Ian Hamilton, for all of this wealth of knowledge. Again,
no problem.
I said you have been getting numerous shout outs, and I want to reiterate your website of hamiltonlawplc.com.
Yes.
And then there's the phone number for you all. Thank you, Francis, for throwing up the information. You all can get a screenshot there, or you'll have it again. This will be recorded. You are in Kalamazoo, Michigan, so people know that. And so easy to get to for those in this community. And so could you just say that, so in case anyone watches from near or far, what's your expansion on who you can assist?
So because of technology, we're able to help anyone in Michigan. Because of Zoom, because of phone calls, we're able to assist anyone. And so we've done a lot of, especially because of COVID, a lot of signings for estate planning via Zoom. We do have that capability to do that. So anywhere in Michigan, we're licensed in Michigan, so we would have to stay in Michigan, but we have the ability to have Zoom or phone and in person.
Wonderful. Thank you so much. This has been very helpful. And thank you all who tuned in. Feel free to share. Let me do one more click. I see new comments. Thank you. And thank you, Julie. I see the love for me. Appreciate it. And so with that, we'll conclude and just remind everybody, this is the first, we hope to be many engagements, if you will, in terms of community care about truth and knowledge and power for us as individuals, for us and our families personally, but also as a community, just information that can be useful to many of us. And so we hope that this message continues to spread. So thank you.
Thank you so much for having me.
Since we're done. Thank you, Ian, but thank you to everyone. Thank you, Francis, and to Truth, Racial Healing and Transformation Kalamazoo for hosting this. Have a great evening, everybody.